Hello. The securities industry plays a critical role in nation development. It complements the banking sector in the raising and investment of funds. In recent time, the securities industry in Ghana has gone through a reform exercise that led to the closure of 53 fund management companies and the suspension of the licenses of others. Behind the vehicle that is implementing these reforms is Reverend Daniel Ogbamitete, a consummate investment banker and a preacher. Reverend is driving change, and that change is having an impact on the industry. We are here in his office to have first-hand information on the status of the reform exercise and to try and understand what next for an industry. I am Maxwell Akalara Dombila, and this is Banking and More. Reverend, welcome to Banking and More.
Thank you.
You have been here since 2017.
That's correct.
And if I'm right, this is your first public sector job.
Yeah, very correct.
What's the difference?
The difference? Well, I think we can say a number of things will differ in terms of how we do things, especially in the public sector and in the private sector. So if I give an example, let's say when it comes to procurement, in the private sector, once you have made a determination of what you need to procure and you've got the support or approval of your board, you simply would go ahead. Of course, you may have some standards. Let's say you may require that you either advertise or get a number of different quotes, etc., etc. So you just follow through. With the public sector, for instance, you must make sure that you route all procurement after your internal processes through the public procurement authority. You need clearance. If you need to do restricted tender, depending on what it is, again, you need approval. So you can see a difference in the process when it comes to procurement and even recruitment. Okay, so I think it boils down to the differences in the processes. In my experience, I used to be a player, so I could see things from the player's perspective. Now, coming over here, you tend to see things more from the policy perspective and seeing things from an industry-wide view of how to make sure that the environment is supportive of the growth and development of the capital market. So I think it's a question of different approaches, especially when it comes to processes. But at the end of the day, you need to deliver on some outputs. And both in the public sector and the private sector, your performance is assessed. Have you delivered? You sign a performance contract. So I think really it's looking at things from a different viewpoint, but fundamentally it's about how you deliver on what is expected of you.
Talking of delivery, while in the private sector, you would have experienced one or two things that were coming from the regulator then that you would have had certain thoughts about. That kind of thinking, that kind of experience from the private sector coming into the public sector as a regulator, has it kind of influenced the decisions you take, the policies you initiate, and the kind of industry you ambition?
Well, I think that for me, coming from industry makes it interesting because I have the perspective of what goes on, if you like, in the industry. And now, with that benefit of knowledge and experience, I'm also looking at it from the policy perspective. And it's interesting. One of the things that the regulator brought up while I was in industry had to do with the issue of guaranteed returns. And the SEC at the time had given the directive that the market players must stop. At that time, I was the vice president of the Ghana Securities Industry Association. So we came, and I was part of the team that came to meet the regulator to negotiate and to say that the directive for an immediate cessation of the guaranteeing of returns could be problematic. It could create some difficulties in the market. So, there was that back and forth. Now, fast forward here I am at SEC in charge, and it's very clear to me that not only is the offering of guaranteed returns illegal by the regulations, but it has been the major source of the difficulties that we are seeing in the fund management space over the last few years. And so in 2018, I had to come out clearly to issue a directive to the market that this practice of guaranteeing returns must cease. The difference is that we gave a certain period. We said within 6 months after the end of 2018, unwind the positions as they mature. Don't make any new offers to your clients offering them guaranteed returns. And then we also did say that at the end of 2018, if you still had difficulties unwinding your positions because of counterparty defaults, inform us and let us know. But it was clear to me that we cannot continue to allow the fund managers to offer guaranteed returns the way it was being done. So that's an example. Back in the day, I had a different view, but after I changed my position on the table,
you had
seeing
a
things differently. Yeah.
And it's interesting that you give them 6 months and for them to unwind and then come within the law. But the concern from others is that the challenges that led to the revocation of the licenses of 53 companies predated those guaranteed returns, or they were part of it, but the fact that they were given 6 months was too short enough for them to comply, and that led to liquidity challenges, and then your outfit had to come in with the actions they came in. From hindsight, don't you think it should have been more?
Actually, I disagree with the view that the 6 months was short, or the directive to stop issuing guaranteed returns is what precipitated the problems. I don't think so. Why don't I think so? So, number one, let me talk about the 6 months. We said that after 6 months, or during the 6 months, as the positions mature, unwind those positions. In other words, we're not saying that terminate the contract immediately. And then we said that, look, after the 6 months, if it happens that because of counterparty defaults, you are unable to unwind the positions, inform the commission, and then we would require you to come up with a plan of action to effectively unwind all those positions. So there was that room, if you couldn't unwind, to inform, because we were aware that, and the industry had made us aware that some could have difficulties because of counterparty default.
Especially coming on the back of the banking sector cleanup, given the interconnectedness.
Yes, but you see, the crux of the matter also has to do with how those funds that the fund managers mobilized, how those funds were dispersed, or how they were invested. Okay. At the time we came up with a revocation announcement in November 2019, one of the things we did say was that the total assets under management of these firms was estimated around 8 billion. It was a little over 8 billion. But if you look at the breakdown, about 5 billion of these assets were at risk. They were at risk because of where they had been invested. Now, if you drill down, you would get to know that a number of them had been given effectively as loans to SMEs and so on and so forth. Now, here's a case where the fund management firms do not, some of them, if not all, do not have the capacity to, let's say, assess the credit worthiness of the prospective borrowers, or they don't have the machinery to do recoveries. Because if you take the banks or the SNLs that are mandated to give credit, and in the first place, fund managers are not licensed to give credit. I mean, they're not licensed to give loans. So if they're doing that, that in itself is wrong. Of course, I know they called it all kinds of interesting names. They call it structured finance, commercial paper, but at the end of the day, they were effectively giving loans. So here's a case where they didn't have the setup, they didn't have the capacity to do so. So they had placed client funds, and those funds had gone bad. So it is not a directive which says that stop guaranteeing returns that immediately precipitated crisis. I think that the distinction is clear, because we are talking about looking at the asset side and looking at the liability. From the viewpoint of the client, they have given money to these fund managers, so that represents monies owed to them, or that represents the liability side. Now, we are saying that, look, fund managers, this practice of offering guaranteed returns, the monies that they bring to you, you say that will give you 20%, 22, 25, it is wrong, it's illegal, stop it. That is different from where the fund manager placed the assets. They use the funds to create assets that were not healthy. So are we saying that because there was a directive that do not offer guaranteed returns, it meant that the asset side was negatively affected? And that's why I'm saying that I disagree. And especially as we give the concession that if you're unable to unwind your positions, inform us, and then we can agree on some plan of action. All we wanted to do was to make sure that no new contracts are issued by the fund managers guaranteeing returns to their clients. That was one. And then for the existing ones, where they couldn't be unwound within the period we gave, they wanted to just, if you like, ring fence them and then have a program where the fund managers would unwind. And that was our way of ensuring that the directive wasn't going to be disruptive. Okay, but I'm telling you that fundamentally, investment decisions were made that were very faulty, because about 5 billion out of the 8 billion assets under management, clearly at risk.
We will come back to that, the structure and the composition of investment in the sector going forward, given the implications. But then the revocations came, and SEC came out to say that the government came out to say that they were going to make due the investments of people impacted. Tell me, what is the state of the process now, bearing in mind the liquidation process provided by under the Act?
Okay, thank you. So let me also stress that we are using the liquidation pathway, because that is the legal option that is available in our enabling acts. SEC, our enabling act is the Securities Industry Act 2016, Act 929. Now in this act, when it comes to fund management companies, if you have to revoke their license because they have failed, the option you have after revoking the license is to notify the official liquidator to go to court to petition the court for the liquidation orders. Okay, so I think that must be clearly understood. I know there's another pathway, which is the receiver pathway, where a regulator can appoint a receiver. But in our Act 929, there is no provision for the SEC to appoint a receiver for fund management companies that have failed. Okay.
I understand why that distinction is important, given the swiftness with the central bank process compared to yours. Going forward, don't you think we should look at what happens in the central bank's process, the receivership, and try to amend or apply it in your end?
Well, to answer your question directly, we are looking at a number of areas in our Act that we are going to push for amendment. And one of the things that we are going to push for is for a framework, a clear framework for the resolution of firms that fail. Okay. Because if you look in the Banking Act, there's a very clear framework when and how a receiver is appointed and so on and so forth. We don't have that kind of elaborate framework, in our act. So we are saying that we have something, and that's why I'm saying if you take, let's say, broker dealers, the act provides for the SEC to appoint a receiver. When it comes to fund management companies, that provision is not there. So we basically want to augment the provisions in our act to make the resolution of failed firms within our space, if you like, more efficient and more effective.
So the current act requires that you inform the Registrar General, and then the Registrar General goes to court, and then gets the orders to act as the official liquidator.
Correct.
They have done that. Now they are acting as official liquidator for some of the fund management companies, but not all. What is the status now, and why that?
Right. So there were 53 companies that in our list issued on the 8th of November that had lost their licenses. Now, after the revocation announcement, a number of them appealed against the revocation decision. There were 8 companies. 3 were successful, the remaining 5 were not successful. So it means that we are talking about 50 firms, fund management firms, that had lost their licenses.
Why were the 3 successful? On what basis?
So the Administrative Hearings Committee is a provision within our Act which allows anyone who is dissatisfied or not happy with anything within the securities industry, or even the decision of the Commission, then they can make the appeal. Now, when they appeal to the AHC would listen to them, especially if they are able to provide or produce new evidence that will support their case for a reconsideration of the revocation decision in this particular case. So for the 3, they were able to produce new evidence that convinced the Administrative Hearings Committee. And let me also be clear that the law defines the membership of the Administrative Hearings Committee, and it doesn't include with the executives of the Commission. So it's almost like a group of people who are constituting the AHC. They hear the case, and then they look at the merits of the case, and then they make a recommendation to the board of the Commission. So that is a process. So there were a number of things that they were able to bring up, which made a strong case. And so one of them had the license restored. 2 of them, even though the license was restored, they were put on suspension. So basically, that is what happened. So but it's 50.
Doesn't that kind of indict the SEC's earlier decision to revoke the licenses? Because then what evidence did you use to arrive at that?
It doesn't, and that's why I said if they're able to bring new evidence, okay, and anyone who would want to probe further can even call for the ruling of the Administrative Hearings Committee, and we'll see the things that make them take that decision. But I know people have raised this question that, does it mean that you didn't do your work well? But listen, decisions of taken in the court can always be reviewed. There's a court of appeal, isn't there? So if you think that a decision has been taken and there's some information that you want to put forward that would make a strong case for you, I think it's a demonstration of people being able to make use of the legal framework, to redress their concerns. So I don't think it's an indictment at all. It's just a demonstration that the system works, in the sense that if you have something that is a strong case that you can put forward to support your position, it would be looked at, and it shows that even if a decision has been taken by the executives of the Commission with the support of the board, and you bring new evidence, that there's a possibility of a reversal. And I think that's what this shows. And I think it should send a signal to capital market operators that, well, there's this provision, so make sure you have a basis to come and say, look, I think, yes, these things were there, but I have this information which shows that I can operate, and it's looked at on its merit, and a decision is made. So that is what it is.
Great.
So
then the 50 companies.
Yes, so I was saying that. So there are 50 companies. The court has granted 22 liquidation orders currently to the official liquidator, and let me stress that the liquidation orders were granted to the official liquidator, not to SEC, because the official liquidator is the one mandated to liquidate firms. So she currently has, and the official liquidator is also the registrar general. She doubles as the official liquidator. So now she has 22 liquidation orders. So there are 22 firms that are under liquidation, official liquidation. So the legal vacation took off the 1st of August. Okay, and my understanding is that it's for 2 months, August and September. So the 22 orders were granted by the court before the legal vacation. So it means that the remaining ones is when the courts resume that the cases will be heard, and then hopefully they would be granted. So the status is that the official liquidator has held creditor meetings. I know she held the creditor meetings last week for all the creditors of these 22 firms. Well, she had 22 liquidation orders, but my understanding is that 20 of them were gazetted. Now there are some processes that she has to go through. After the liquidation order is granted, she needs to gazette them, let everybody know that these companies. So 20 of them were gazetted. So actually last week she met with the creditors of all these 20 fund management companies under official liquidation. Okay, so the remaining 2 would be added to the next batch when the orders are received. And I know that this week the official liquidator will be meeting the clients or the investors of these firms. Now the distinction is that when we talk about creditors, it's not only the clients who took monies to these firms. Creditors can include suppliers, they can include let's say even employees, it can include public agencies like SNIT, GRA, and so on and so forth. So they are all creditors. Okay, so when a company is in liquidation, the official liquidator needs to meet with all these creditors. So that's what happened last week. Okay. So the creditors include clients who invested money with these firms. But this week, the meeting is only with the clients who invested money. That is what we call a class meeting for investors.
This is still Banking and More, and we are here with Reverend Daniel Ogbami-Tetteh, Director General of the Securities and Exchange Commission. We are trying to understand the status of the reform exercise, an exercise that led to the revocation of the licenses of 53 companies. 8 of those companies have since appealed, and they've succeeded in getting the SEC to rescind its decision after the hearing. Reverend, you were talking about the creditor meetings, and like you explained, there are 2 types: those that invested in the companies and those that rendered other services to the company that the company owes them. When we talk of the non-investor creditors, you have an idea how much of their portfolio is currently locked in?
Okay. So maybe let me just clarify. I didn't say that, or I didn't mean to say that there were 2 groups of creditors. There are a number of creditors. I just give examples like suppliers. But anyone who has a claim against the entity is a creditor, including the investors. The official liquidator asked all the creditors to file claims with her outfit. So I'm not in a position to indicate the value of the claims that have been filed with her. I know the value of claims filed by the clients, those who invested money with these firms, because after the revocation decision, one of the things we did was to mandate an agent to receive claims from the affected clients. So I can speak to that. For the 22 firms that are under official liquidation, the claims that the client filed against these 22 firms came to a little over 1.5 billion. Okay, 1.5 billion. Now, we always have to distinguish between the claims filed and validated claims, because the fact that you filed a claim doesn't mean that the claim is valid. You know, our job is to make sure that, number one, the rightful claimants are the ones making the claims, and number two, the rightful claimants are making the right claims. So we need to go through a validation process. So we mandated the same agent after receiving the claims to go through validation. So the claims received 1.5 billion, the validated claims is 1.08 billion. Okay, so basically, if you are talking about the bailouts that would be rolled out to the clients of these 22 fund management firms under official liquidation, what government is looking at, because government has said that they will provide a bailout against the validated claims, not just the claims, because I can tell you that there were some of the clients, we understand, in the run-up to revocation, that some of the firms maybe gave some did some asset swaps, maybe a car, because the clients may have been put in pressure. So, and some, maybe they had some money, they paid part. So it is possible that someone would have filed a claim, the person didn't receive an updated certificate. So even though the person had received either some part payment or some asset sales, from where he or she is concerned, she doesn't have or he doesn't have the new certificate, but the firm would have updated it in their system. So if they are filing, they file with what they have, and that's why we need to validate, look at what is in the system of the firm, to make sure that it matches. There are also some people who want to test the system. They think that if there's a bailout, free for all, let's also try and get in there. So validation is important. So the claims, the value of the claims is for the 22 firms, 1.5 billion, but the validated position is 1.08 billion.
And one of the concerns is coming from the major player at the time, now former Black Shield, formerly Gold Coast. Their investors are very vociferous, and I think they constitute about 80%, 83% of the entire investor portfolio. What is it that is making SEC unable to include them in the order that the court needs to give for the liquidation process to continue?
Okay, so let me again correct that. It's not an issue of we are not including them. It's a question of the process. Let me take maybe one or two steps backwards. Now, when we engaged the government after we did the revocation into throwing a bailout package, there were two things that government indicated they would want to see happen, if you like, as a precondition to the rolling out of the bailout package. One is that the claims filed by the clients or the investors must be validated. And then two is that the liquidation orders must be secured. Okay, so these two things must happen. The court must grant the liquidation order because we are using the liquidation pathway. I just want to keep stressing that. And then two, the claims must be validated because you cannot just pay claims without going through a certain process. Okay. I think I explained earlier that the official liquidator has petitioned the court. Now, the liquidation petition is on notice, and the firms have an opportunity to also put in an appearance, contest the liquidation petition and all of that. So it's a court process that takes time. Okay, so all I'm saying is that as at the end of July and before the legal vacation, the court had granted 22 liquidation orders. And even that, I know the official liquidator had to petition the judicial service for one court to be dedicated to the hearing of the cases, because if the cases previously they were scattered in a number of different courts, and that would have made the process very long. But that action by the official liquidator to petition the judicial service for a dedicated court helped, and so 22 orders have been granted. And you talk to anyone, they will tell you that to get 22 liquidation orders in a period of, let's say, 2 to 3 months is a real achievement. Okay, so that
November and then now, isn't that a bit? The revocations happened last year.
Yes.
And now, or
no. So you have to understand it's a process, and let me again explain. I said that the liquidation petition is on notice. It means that you have to serve notice to the directors of the firm that a petition for liquidation of your firm is going to be in court. Now, if it takes a month to locate the directors, to serve them the notice, that delays even when the petition can be heard in court, because it's by notice. You have to find them. So it took some time to serve notice on a number of the directors. In fact, in some cases, the official liquidator even had to do substituted service, where it's published, because you had tried. But you must try, or use all means available to serve the notice. So that can affect the time that the petition will be heard. Now, I also said that this, petition, it can be contested. Okay, so it goes through the court process. No one controls the court process. But I'm telling you that what the court has been able to achieve within the, let's say, the period that they have been at it is remarkable. Don't also forget that, for the most part of March and April, I think sometimes people tend to forget it. We had a lockdown in March into April. For the most part of March and April, there was very little action. Even, the courts were also, closed for a while. So, all these things impact the timing. Okay, but let me come to Black Shield, because you asked about that, because I wanted to give you a general view for you to understand that there are processes. Now, in the case of Black Shield, there are two things. One is that after the revocation decision, they appealed to the Administrative Hearings Committee. They were one of the 8. Okay, you remember I mentioned that there were 8 companies, and not all the 8 companies were successful. It was 5 that were unsuccessful, 3 were successful. Okay, but Black Shield was one of the 8. Okay. Now, the decision of the Administrative Hearings Committee on Black Shield, in particular, came out in June. It came out in June because of a number of processes. So, Black Shield in particular made, requests for some, if you like, changes that were accommodated. Let's say in the procedure for the hearing of their case. But let me not even get into the details. The main thing is that if Black Shield is at the Administrative Hearings Committee, do you think that the liquidation petition can be started in court? The answer is no. Because if you start the liquidation petition, it means that the Administrative Hearings Committee process is like an academic exercise. Okay, so we had to wait for the Administrative Hearings Committee to terminate, because if you initiate the liquidation process, it means that you don't even have faith that and that, because Administrative Hearings Committee, I told you, they will look at all the evidence that you bring, new evidence especially, and then they'll make a decision. So we couldn't have started the liquidation petition for where Black Shield is concerned, because they were at the AHC. So we had to wait for the AHC to end. Now, as soon as we came up with the AHC decision, they went to court to filed a case that they were not given a fair hearing by the AHC. And they went to court in June, but the date for the hearing to commence was on the 28th of July. Okay, and you can imagine that, you know, a case cannot be, you can't start the hearing on the day and then have it concluded, because it goes through some processes. Okay, so long story short, the liquidation order for Gold Coast, we don't have it. Remember I said there were two conditions: the liquidation order and then the validation of the claim. So that's on the liquidation. Because it came to AHC, we had to wait. We couldn't have started. So I think it's important you put this in context and don't say, oh, November to this is a long time, because that is a reality. Okay, because processes, and I think when we started this conversation about public service, I was talking about processes. So it's a question of the processes. Now let me talk about the validation of claims.
Before that, this issue with Black Shield, because of the size of their investors and even the value of it, they tend to dictate the pace at which the conversation around the resolution, the liquidation process, it's ongoing, and it's understandable. What will be the final end? Because they are in court obviously contesting your action. You also need to make deal with the customers, giving government commitment. What is the way out?